I remember the day we first pulled into Oakwood Heights. The subdivision looked like something out of a real estate brochure: pristine lawns, coordinated mailboxes, and that peculiar suburban quiet that whispers promises of safety and stability. After 3 years of apartment living and constant relocation for my cases, I had finally saved enough for a proper house with a yard, a place where my 12-year-old son, Noah, could finally put down roots. "What do you think, buddy?" I asked, turning to look at Noah in the rearview mirror. He was gazing out the window, his expression cautiously hopeful as he signed "nice" with his right hand. Beside him sat Jasper, his golden retriever service dog, nose pressed eagerly against the glass, tail sweeping across the backseat in gentle approval. Jasper was not just a pet. He was Noah's ears, his safety net, his constant companion. Noah had been deaf in his right ear since birth, with significant hearing loss in his left that had progressively worsened since he was 8. The world was a muffled, often frightening place for him, but Jasper changed everything. Trained to alert Noah to doorbells, alarms, approaching vehicles, and even his name being called, Jasper had given my son the independence that every growing boy craves. We unloaded our modest belongings into the 2-story colonial that would become our home. I watched as Noah and Jasper explored the backyard together, my heart swelling with something I had not felt in a long time: hope. Perhaps here, in this orderly neighborhood with its good schools and low crime rate, we could finally build something permanent. Our first encounter with Karen Wilkins happened 3 days later. I was planting flowers along our front walkway when a shadow fell across the soil. I looked up to see a woman in her 50s wearing a pastel blue pantsuit that matched the clipboard she clutched against her chest. Her blonde hair was cut in a precise bob, not a strand out of place despite the April breeze. "You must be Elaine Matthews," she said, her smile not quite reaching her eyes. "I am Karen Wilkins, president of the Oakwood Heights Homeowners Association. I wanted to personally welcome you to our community." I stood, dusting soil from my hands before extending one. "Thank you. We are really enjoying it so far." Her gaze drifted past me to where Noah and Jasper were playing fetch in the front yard. Something flashed across her face, a momentary tightening around the eyes, a slight downturn of her lips. "I see you have brought a pet with you," she said, her voice taking on a different tone. "I should inform you that Oakwood Heights has strict policies about unregistered animals. All pets must be approved by the HOA committee." Just then, Jasper trotted over, his service vest clearly visible with its official patches, and "Do Not Pet" working dog embroidery. Noah followed, his hearing aids visible if one bothered to look closely. "Actually, Jasper is not a pet," I explained patiently. "He is a certified service animal for my son who has hearing impairments. Under federal law, service animals are not subject to pet restrictions." Karen's smile remained fixed, but her eyes hardened. "Oh, of course. We certainly respect all applicable laws. However, our HOA does maintain a registry of all animals, service or otherwise, for community safety. I will need to see his certification and your son's medical documentation." I felt a flash of irritation but maintained my composure. "I would be happy to show you Jasper's service certification. As for my son's medical information, that is private. The Americans with Disabilities Act does not require us to disclose his medical details." "We just want to make sure everything is legitimate," Karen said, her voice dripping with false concern. "You understand, some people claim their pets are service animals just to get around the rules." "I understand your concern," I replied evenly. "I can assure you that Jasper is a properly trained service dog. I actually specialize in animal rights law, so I am very familiar with the regulations." Something changed in Karen's expression then, a slight narrowing of the eyes, an almost imperceptible stiffening of her shoulders. She nodded briskly. "Well, welcome to Oakwood Heights. The monthly HOA meeting is this Thursday at 7:00 p.m. in the community center. I strongly encourage all new residents to attend." As she walked away, I could not shake the feeling that I had just made some kind of enemy. Her parting glance at Jasper carried a weight I could not quite define, but it left me unsettled. That Thursday, Noah, Jasper, and I attended the HOA meeting. The community center was filled with about 30 residents, most of whom greeted us warmly. Karen sat at the head table with 4 other board members, her posture perfect, her expression unreadable. When it came time for new business, Karen gestured toward us with a sweeping hand. "I would like to introduce our newest neighbors, Elaine and Noah Matthews. They have moved into the Sullivan property on Maple Drive." She paused, then added, "And they have brought an animal that they claim is a service dog." The word claim hung in the air like a challenge. I felt Noah tense beside me. I stood calmly. "Thank you for the introduction. This is indeed Jasper, a certified hearing service dog for my son who has auditory impairments. We have all the proper documentation and are happy to be part of this community." I offered the folder containing Jasper's certification papers, his training records, and my laminated ADA information card. Karen took it with 2 fingers, barely glancing at the contents before passing it to another board member. "We will review these and get back to you," she said dismissively. "Now, moving on to the matter of seasonal decorations." As we left the meeting, an older gentleman approached us in the parking lot. "Do not take it personally," he said quietly. "Karen has been like this since they elected her 3 years ago. Power went straight to her head." I thanked him for his kindness, but as we drove home, I could not shake the feeling that something was brewing beneath the surface. Still, I was determined to give our new home a fair chance. After all, we had faced challenges before. How bad could one power-hungry HOA president really be? I would soon find out exactly how bad. The first notice arrived exactly 1 week after the HOA meeting. A white envelope with the Oakwood Heights logo embossed in gold slipped under our front door while we were out grocery shopping. Inside was a formal citation for lawn maintenance violation grass exceeding 3.5 inches in height in southeast corner of property. I walked outside with a measuring tape. The tallest blades of grass in our entire yard barely reached 3 inches. 3 days later, another notice appeared. Improper trash receptacle placement bin must be placed no less than 12 inches and no more than 18 inches from curb edge. The notices continued. The color of our mailbox was antique white rather than the approved classic cream. Our porch light was 5 watts brighter than regulations permitted. Noah's basketball hoop, despite being portable and stored in our garage when not in use, was deemed an unapproved recreational structure. Each violation came with a warning that fines would follow if not corrected promptly. Each was signed with Karen's flowing signature. "This is ridiculous," I muttered one evening, sorting through the growing pile of notices on our kitchen counter. Noah watched my face carefully, always sensitive to my moods despite not being able to hear my tone. "Are we in trouble?" he signed, his young face creased with worry. "No, honey," I signed back. "Just silly grown-up stuff, nothing for you to worry about." But the real blow came 2 weeks after we moved in. An official certified letter requiring signature upon delivery. Inside was a formal HOA complaint titled "Unauthorized Pet on Premises." The letter stated that, despite verbal warnings, resident continues to harbor an unregistered animal on the property in direct violation of HOA Covenant Section 7, Paragraph 3. It demanded that the pet situation be rectified within 72 hours, or we would face daily fines of $150. I sat down at my computer and drafted a response that same evening, citing the relevant sections of the Americans with Disabilities Act, the Fair Housing Act, and 3 major federal court precedents that protected service animals from housing restrictions. I attached digital copies of Jasper's certification, training records, and a statement from Noah's audiologist about his need for a service animal. My email was polite but firm, concluding, "As I am sure you are aware, federal law protects service animals from being classified as pets under housing restrictions. Any attempt to remove or restrict Jasper would constitute discrimination against my son's disability, which could result in serious legal consequences for the HOA. I trust this clarifies the situation." Karen's response came the next morning. It was brief and icy. "The HOA board has reviewed your documentation and finds it insufficient. Oakwood Heights requires all service animals to be registered using our special accommodation request form and undergo an independent evaluation by our approved veterinarian. Until this process is completed, your animal remains in violation of community guidelines. The 72-hour notice stands. Attached was a 12-page special accommodation request form that asked for everything from Noah's complete medical history to Jasper's genetic lineage. It included a waiver of privacy rights and permission for the HOA to contact Noah's doctors directly. Most disturbingly, it required us to allow an HOA representative to observe Jasper's service functions in our home. It was blatantly illegal. No HOA had the right to demand medical records or override federal disability protections with their own approval process. But I did not respond with the legal firestorm I could have unleashed. Not yet. Instead, I began documenting everything, saving emails, photographing notices, recording dates and times. Something told me this was just the beginning. The next phase of Karen's campaign became more personal. Noah began noticing a car that would slow down whenever he walked Jasper after school. Twice, he came home upset, signing frantically that a woman had been taking pictures of him and Jasper from her car. One Saturday morning, I was in the front yard with Noah and Jasper when Karen's silver Mercedes cruised by, slowing to a crawl. Through the passenger window, I clearly saw her raise her phone, the camera lens glinting in the sunlight as she photographed us. That evening, another notice appeared. Unleashed pet in front yard, first warning. The attached photo showed Noah and Jasper playing fetch. The image was cropped to hide the long training lead attached to Jasper's service harness. Noah began to show signs of stress. He started asking to keep Jasper inside. He checked the windows before going into the backyard. His teacher called to tell me he seemed withdrawn at school. "Is something wrong at home?" she asked during our phone conversation. How could I explain that my 12-year-old son with hearing impairments was being stalked by a middle-aged woman with a clipboard and too much time on her hands? The situation reached a breaking point when Noah and I returned from his audiologist appointment to find yet another notice, this one wedged aggressively into our door frame. Final warning, dangerous animal on premises. The letter claimed that multiple residents had reported aggressive behavior from our large breed dog, including lunging, excessive barking, and threatening postures toward children. It was absurd. Jasper was one of the most rigorously trained service dogs in the state. He had never lunged at anyone. And as for excessive barking, he was specifically trained not to bark except in alert situations. That night after Noah was asleep, I sat in the kitchen with a legal pad and began mapping out my strategy. This was no longer about petty HOA overreach. This was targeted harassment of a disabled child. Karen had picked the wrong family to bully. Little did I know that she was about to escalate beyond anything I could have anticipated. Wednesday, May 12th, a date forever etched in my memory. I had a court appearance that morning, a routine hearing that should have taken an hour but stretched to 3 due to procedural delays. I texted our neighbor, Mrs. Garcia, who often checked on Noah after school when my cases ran long. She confirmed that she had seen him arrive home safely with Jasper at 3:15. When I finally pulled into our driveway at 4:45, something felt wrong immediately. The house had that particular emptiness that resonates even from outside. No welcoming thump of Jasper's tail against the floor. No sound of Noah's footsteps. I found my son curled on his bed, his body racked with silent sobs that broke my heart. When he looked up, his eyes were red and swollen, his hands shaking too much to sign clearly. "Noah, what happened? Where is Jasper?" I signed, my hands steady despite the panic rising in my chest. It took several attempts before he could respond coherently. "The HOA lady, she took him. She said he attacked someone." The world seemed to tilt on its axis. I ran to check our security cameras, a system I had installed precisely because something in my gut had warned me we might need documentation. The footage was clear as day. At 3:45 p.m., Noah had taken Jasper into the backyard. At 3:52, Karen appeared at our side gate with another woman I recognized as the HOA treasurer. She had a document in her hand and what appeared to be an official-looking ID card around her neck. She spoke to Noah through the fence. His body language showed confusion, then distress. Karen opened the gate, which violated multiple laws right there, and entered our property with a leash. Whatever she said next caused Noah to back away, clearly frightened. The other woman said something to him while pointing at the papers. Noah, confused and unable to fully hear or understand their rapid speech, froze, a response he often had when overwhelmed by communication challenges. Karen took advantage of his hesitation to clip her leash to Jasper's collar. The service dog looked confused, glancing between Noah and the strangers. As they began leading Jasper away, Noah snapped out of his shock and tried to intervene. Karen showed him something on her phone that made him step back in distress. They left with Jasper, closing our gate behind them as casually as if they were borrowing a cup of sugar. My blood turned to ice, then fire. I grabbed my phone and called Karen directly. "Where is my son's service dog?" I demanded when she answered. "Mrs. Matthews," she replied, her voice carrying that artificial sweetness that made my teeth ache. "There has been an incident involving your animal. As HOA president, I have a duty to protect our residents." "What alleged incident? And you have absolutely no authority to enter my property or remove a service animal. Return Jasper immediately, or I am calling the police." "The police have already been notified," Karen said, her voice hardening. "Your dog was observed behaving aggressively toward a child this morning. When confronted about it, your son became uncooperative. As per Section 12 of our HOA emergency protocols, the board has the right to remove dangerous animals pending investigation." "That is complete fiction, and you know it," I said, struggling to keep my voice level. "Jasper is a trained service animal protected by federal law. What you have done constitutes theft, trespassing, and violation of the Americans with Disabilities Act." "Feel free to take that up with animal control," she replied smoothly. "They have custody of the animal now. I recommend you contact them directly." She hung up. I immediately called the police, my hands shaking with rage and fear. While waiting for them to arrive, I comforted Noah as best I could, assuring him that we would get Jasper back. The officers who responded to my call were professional but reserved. I showed them the security footage and explained Jasper's status as a service animal. They took notes and appeared sympathetic, but their demeanor changed when they received a call from their dispatcher. "I am sorry, Mrs. Matthews," the older officer said after hanging up. "But animal control has already been involved. There was a report filed this morning claiming your dog bit a 10-year-old child in the neighborhood while your son was walking him before school." "That is impossible," I said firmly. "My son does not walk Jasper alone before school. We left together this morning at 7:30. I dropped him off myself. Check the school attendance records." The officer nodded. "We will investigate that discrepancy. However, there is a signed statement from a witness claiming they saw the incident at approximately 7:15 a.m. on Oakwood Drive." "We have never walked on Oakwood Drive," I insisted. "That is on the opposite side of the neighborhood from our route to the bus stop." Despite my protests, the officers explained that animal control had placed Jasper in a mandatory 10-day quarantine pending a behavior assessment. They provided me with contact information and case numbers, but made it clear that retrieving him would not be simple. As they were leaving, one officer paused. "Just out of curiosity, what do you do for a living, Mrs. Matthews?" "I am an attorney," I replied. "I specialize in animal rights law." A flicker of something surprise, perhaps even a hint of amusement, crossed his face. "Interesting coincidence," he murmured before heading back to his cruiser. It was no coincidence. Karen had targeted my son's service dog without realizing she had just declared war on someone who had dedicated their career to fighting exactly this type of injustice. I called animal control immediately, identifying myself both as Jasper's owner and as a practicing attorney. The staff member who took my call seemed uncomfortable when I explained the situation. "I am not supposed to say this," she said, lowering her voice, but the complainant was very insistent about keeping the dog quarantined for the full assessment period. She mentioned connections with the city council and was persuasive. "I will be there first thing tomorrow morning with all of Jasper's documentation," I said firmly, "including proof that he was not where this alleged incident occurred." That night, Noah cried himself to sleep. Without Jasper to alert him to sounds, he jumped at every vibration, every shadow. I sat at my desk until 3 a.m., printing documents, making calls to colleagues, and preparing for battle. Karen had no idea what she had started. By 8 a.m. the next morning, my kitchen table had transformed into a war room. Documents were arranged in precise stacks: Jasper's service certification and training records, Noah's IEP from school documenting his hearing impairment, federal ADA regulations regarding service animals, state laws on impersonating officials, trespassing statutes, and personal intimidation codes. I made 3 critical calls before heading to animal control. The first was to Richard Stevenson, my former law professor and mentor, now the head of the state's Disability Rights Commission. The second was to Sandra Miller at the Department of Justice's ADA Compliance Office. The third was to my colleague Marcus Washington, whose specialty was HOA overreach cases. All 3 were appalled by the situation. All 3 promised immediate action. At the animal control facility, I presented Jasper's complete records, including his spotless behavior assessments and specialized service training certifications. I brought Noah's school attendance record from the previous day, proving he could not have been walking Jasper at the time of the alleged incident. Most importantly, I presented the security footage showing Karen illegally entering our property and removing Jasper under false pretenses. The animal control supervisor, a veteran officer named Davis, reviewed everything carefully. "This is highly irregular," he admitted. "The complaint was filed with very specific details, including a doctor's report for the allegedly bitten child." "I would very much like to see that report," I said, "and I would like to know which doctor supposedly treated this non-existent injury." Officer Davis hesitated. "I cannot release that information without a formal request." "Then consider this my formal request, both as the owner of the accused animal and as legal counsel in this matter. Additionally, I am filing a counter-complaint for false reporting and harassment." He seemed relieved, as if he had been looking for a reason to side with me. "I will expedite Jasper's behavioral assessment. Given these circumstances, we should be able to complete it by tomorrow instead of waiting the full 10 days. "I would also like to see him now," I insisted. Jasper was being kept in a special section reserved for service animals, away from the general population. When he saw me, his tail wagged furiously, but I noticed immediately that something was wrong. He seemed anxious, unsettled. One of his paws was bandaged. "What happened to his paw?" I demanded. The handler looked uncomfortable. "He came in with that injury. The intake report says he sustained it during the alleged incident." Ice formed in my veins. "Are you telling me that someone injured my son's service dog to create evidence for a false complaint?" No one would answer directly, but their expressions told me everything I needed to know. When I returned home, I found our mailbox smashed, the metal door hanging from one hinge. Inside was another HOA violation notice, this one claiming we had failed to pay the last 3 violation fines, now totaling over $1,200. That afternoon, I called an emergency neighborhood meeting at the local coffee shop, deliberately choosing a venue outside HOA property. I was surprised when 12 neighbors showed up. Some faces were familiar from the HOA meeting, others I had never seen before. I laid out everything: the harassment, the illegal removal of Jasper, the fabricated bite report. I showed them the security footage on my laptop. "This is not just about my family," I explained. "This is about abuse of power that affects everyone in Oakwood Heights. Today it is my son's service dog. Tomorrow it could be your garden, your holiday decorations, your right to feel safe in your own home." The room divided visibly. Some neighbors were outraged on our behalf. Others shifted uncomfortably, avoiding eye contact. An older woman named Helen finally spoke up. "We all know Karen has gone too far this time, but some of us have lived here for decades. We cannot afford the legal battles or the fines if we stand against her." "You will not have to," I assured them. "I am taking this to court, and I am doing it pro bono for anyone else who has experienced similar harassment." A younger couple shared that they had been fined for having a remembrance flag for their son who had died in military service. Another resident, a retired teacher, had been harassed about her rose garden because it did not use HOA-approved varieties. A single father had received violations for his daughter's adaptive bicycle, which she needed for her physical therapy. Pattern after pattern emerged, painting a picture of systematic intimidation disguised as community standards. As the meeting concluded, half the attendees signed statements documenting their experiences with Karen and the HOA board. The others wished me well but were too afraid to formally get involved. When I arrived home, I found notices plastered across my front door: final warnings, threatened liens, even a notice of intent to begin eviction proceedings for creating a dangerous environment. That night, after Noah was asleep, I sat at my computer and began drafting the most comprehensive legal complaint of my career. I would not just be fighting for Jasper now. I would be fighting for every resident who had ever felt bullied, intimidated, or silenced. The next morning, my car had 2 slashed tires. Karen had clearly decided to declare total war. She had no idea what was coming her way. The animal control assessment for Jasper was scheduled for 10 a.m. on Friday. I arrived at 9:30 with Noah, who had refused to go to school until Jasper was home. His teacher had been understanding, sending his assignments electronically. The assessment room was small and clinical, with cameras mounted in each corner. To my surprise, Karen was already there, seated primly in a chair against the wall. "What is she doing here?" I demanded of Officer Davis. "This should be a closed evaluation." "Mrs. Wilkins requested to observe as a representative of the complainant," he explained uncomfortably. "Since this is not a formal court proceeding, we cannot legally exclude her." I glanced at Noah, who was watching Karen with undisguised anxiety. "Fine, but I will be recording this entire process independently," I said, setting up my phone on a tripod. When Jasper was brought in, the change in Noah was immediate. His entire body relaxed, his breathing steadied. Jasper strained toward him, his training barely containing his excitement. The evaluator, a certified animal behaviorist, began by checking Jasper's response to basic commands. He performed flawlessly. The assessment continued with tests for aggression triggers, loud noises, sudden movements, food protection. Jasper remained calm and focused. Then the evaluator brought out a child-sized mannequin and began moving it erratically near Jasper. I noticed Karen leaning forward intently. "Please move the mannequin closer to the dog's face," she called out. "That is how the incident occurred." The evaluator glanced at her, then at me, clearly uncomfortable with the interference. "Actually," I interjected, "as this is a service animal assessment, I would like to see him evaluated on his actual service functions for my son, not on artificial scenarios designed to provoke a reaction." The evaluator nodded, seeming relieved at the suggestion. He asked Noah to demonstrate how Jasper assisted with his hearing impairment. Noah signed to Jasper to alert to sounds, and the evaluator tested this by playing various noises: doorbells, alarms, voices from different directions. Jasper performed each alert perfectly, gently nudging Noah and guiding him toward the sound source. Karen's face darkened with each successful demonstration. When the evaluator declared that Jasper showed no signs of aggression and exemplary service training, she stood abruptly. "This assessment is incomplete," she protested. "The dog behaved completely differently during the incident. I have a witness waiting outside who can testify to what really happened." Officer Davis sighed heavily. "Mrs. Wilkins, this is a behavioral assessment, not a trial. The animal has passed all standard evaluations." "I insist that you hear from my witness," Karen demanded. or I will be forced to escalate this to city authorities. Against my objections, a nervous-looking woman was brought in. She introduced herself as Diane Pearson, a resident of Oakwood Heights. With Karen nodding encouragingly, she described seeing Noah walking Jasper aggressively and the dog lunging at her daughter, allegedly breaking skin through her jacket. I waited until she finished her story, then asked calmly, "Mrs. Pearson, what time did this incident occur?" "Around 7:15 in the morning," she replied. "And where exactly?" "On Oakwood Drive, near the community mailboxes." I nodded, then turned to Officer Davis. "I would like to submit into evidence the following. My son's school attendance record showing he arrived by bus at 7:25 that morning, making it impossible for him to be at the alleged location at 7:15. Our home security footage showing us leaving together at 7:05 and driving directly to his bus stop on Maple Street, which is in the opposite direction from Oakwood Drive. And finally, Mrs. Pearson's own social media post from 7:18 a.m. on the day in question, showing her at a breakfast meeting 5 miles away from Oakwood Heights. The room fell silent, Mrs. Pearson's face drained of color. Karen's mouth opened and closed without sound. "How did you?" Mrs. Pearson began. "Basic investigation," I replied simply. "The question now is whether you would like to face charges for filing a false report, or if you would prefer to correct your statement." Within minutes, Mrs. Pearson was retracting her story, admitting that Karen had asked her to help the community by supporting the complaint with her testimony. The evaluation concluded with the behaviorist signing off on Jasper's perfect assessment. Officer Davis apologized for the ordeal and began processing Jasper's release papers. Karen stormed out without another word, but the damage to her credibility was done. By that afternoon, Officer Davis called to inform me that the bite report had been officially classified as unfounded, and all records regarding the false complaint would be expunged. However, our victory was short-lived. When we arrived home with Jasper, we found a notice of emergency HOA board meeting scheduled for that evening. The agenda had one item: dangerous animal remediation, Matthews residence. Despite the animal control clearance, Karen was taking her case to the HOA board, where she still wielded considerable influence. We had won the battle, but not yet the war. I spent the next 3 hours calling in reinforcements. By the time the emergency board meeting convened at 7 p.m., I had assembled a formidable team. Richard Stevenson from the Disability Rights Commission, Dr. Julia Chen, Noah's audiologist, Michael Torres, a certified service animal trainer who had worked with Jasper, and Marcus Washington, my HOA litigation specialist colleague. The community center was packed. Word had spread about the confrontation at Animal Control, and residents were curious to see what would happen next. Karen sat at the head table with the other 4 board members, her composure visibly strained. When she called the meeting to order, her voice had a brittle quality I had not heard before. "This emergency session will address the ongoing safety concern regarding an animal at the Matthews residence," she began. I raised my hand immediately. "Point of order. Before this discussion proceeds, I would like to introduce my legal team and expert witnesses who will be documenting this proceeding." Karen's eyes widened slightly as my colleagues stood one by one, stating their credentials. The other board members exchanged nervous glances. "Additionally," I continued, "I have filed official complaints today with the Department of Justice Civil Rights Division, the State Attorney General's Office, and the County Housing Authority regarding multiple violations of the Americans with Disabilities Act, the Fair Housing Act, and state anti-discrimination laws." A murmur ran through the crowd. One of the board members, a retired accountant named Bill Jensen, cleared his throat. "Perhaps we should postpone this discussion pending legal review," he suggested carefully. "Absolutely not," Karen snapped. "We have community safety concerns that cannot wait for bureaucratic procedures." What followed was a masterclass in professional intimidation. My team and I systematically dismantled every claim Karen presented. Dr. Chen explained how crucial Jasper was to Noah's independence and safety. Michael Torres walked the board through Jasper's extensive training and certification. Richard Stevenson outlined the serious legal consequences the HOA would face if they continued this discriminatory action. When Karen attempted to introduce her witness, again, Marcus Washington interrupted. "I should advise the board that Mrs. Pearson has already retracted her statement and admitted to fabricating evidence at Mrs. Wilkins' request. This is documented with Animal Control and the police department. Continuing to present her testimony could constitute knowing promotion of false information, which carries its own legal liabilities." By the end of the hour, 3 of the 5 board members were visibly distancing themselves from Karen. Bill Jensen finally spoke up again. "I move that we dismiss all complaints against the Matthews family and their service animal, effective immediately, and that we formally rescind all related fines and notices." The motion carried 3-2, with only Karen and her closest ally voting against it. It should have been a victory, but as the meeting dispersed, Karen approached me with cold fury in her eyes. "This is not over," she hissed. "The HOA bylaws give me executive authority during community emergencies. One way or another, your dog will be removed." Her threat sent a chill through me. Despite everything, she was still determined to target my son's service animal. I realized then that this would not end until I took more drastic action. "See you in court, Karen," I replied quietly. As I presented our opening statement, I kept my emotions firmly in check, focusing on the facts, the timeline, and the law. I detailed the escalating pattern of harassment, the fabricated complaints, the illegal seizure of Jasper, and the profound impact on my son's well-being. "Your Honor," I concluded, "this case is not merely about an HOA dispute. It represents a deliberate attempt to circumvent federal disability protections and target a vulnerable child through his medically necessary service animal. The respondents not only violated multiple laws, but did so with full knowledge of their actions and with malicious intent." Karen's attorney, Mr. Harrington, presented their defense with polished precision. According to him, the HOA had acted within its authority to protect community safety. He characterized Karen as a diligent board president who had received concerning reports about an animal and had simply followed established protocols. He painted me as an overly litigious parent who refused to comply with reasonable community standards. "The HOA has no issue with legitimate service animals, Your Honor," he said smoothly. "Our concern was solely with proper registration and community safety." Judge Mercer's first question cut straight to the heart of the matter. "Counselor, are you suggesting that HOA regulations supersede federal disability law?" Mr. Harrington faltered momentarily. "No, Your Honor. We contend that the HOA was attempting to work within federal guidelines while maintaining their responsibility to the community. And this responsibility included removing a certified service animal from a disabled child without due process?" Judge Mercer asked, his eyebrow raised. The tone was set. Throughout the proceedings, Judge Mercer repeatedly challenged the defense's characterization of events, often referring directly to the documentation I had submitted. The turning point came when Noah took the stand. At 12 years old, he appeared small and vulnerable in the witness chair, but his composure was remarkable. Through a sign language interpreter, he described his relationship with Jasper, how the dog helped him navigate a world he could not fully hear, and how frightened he had been when Jasper was taken. "Jasper is not just a dog," he signed clearly. "He is my ears. He lets me know when someone is at the door or when a car is coming. He wakes me up when my alarm goes off. Before Jasper, I was always scared to be alone." When asked about the day Karen took Jasper, Noah's hands trembled slightly, but his signs remained precise. "They said Jasper hurt someone, but I knew that was impossible. He never barks or jumps at people. He is trained not to. When they took him away, it felt like they took part of me." Karen's attorney declined to cross-examine Noah, a wise decision given the sympathy the boy had clearly evoked in the courtroom. When Karen took the stand, Her carefully constructed facade began to crack under my cross-examination. Mrs. Wilkins, did you or did you not receive documentation confirming Jasper's status as a certified service animal within days of our moving into Oakwood Heights? I received some papers, yes. And did those papers clearly identify Jasper as a service animal protected under the ADA? They appeared to be service animal documentation. Yet you continued to classify him as a pet in all HOA correspondence. Is that correct? Our HOA has specific requirements for. Please answer the question, Mrs. Wilkins. Did you continue to classify a documented service animal as a pet in official HOA notices? Yes. Step by step, I led her through each violation, each fabrication, each overreach of authority. When presented with the security footage of her taking Jasper, she claimed she had been invited onto the property, a claim immediately contradicted by the video evidence. The most damning moment came when I questioned her about Diane Pearson's false testimony. Mrs. Wilkins, did you ask Mrs. Pearson to provide a statement about an incident she did not witness? Corinne's attorney objected immediately, but Judge Mercer overruled him. I simply asked her to support the community standards we all agreed to uphold, Corinne replied stiffly. Did you or did you not specifically instruct her to claim that Jasper bit a child, knowing that no such incident occurred? I would not characterize it that way. How would you characterize asking someone to make a false statement to animal control authorities? Her composure finally cracked. Someone needed to do something. People move into our community and think they can ignore the rules that everyone else follows. They wave around their special paperwork and expect special treatment. The courtroom fell silent at her outburst. Judge Mercer leaned forward. Mrs. Wilkins, are you referring to federally mandated accommodations for disabilities as special treatment? She realized her mistake too late. I simply meant that our community has standards that benefit everyone. Including disabled children, Judge Mercer asked pointedly. By the afternoon of the second day, the momentum had clearly shifted. Several board members testified that Corinne had acted largely on her own authority, often informing them of actions after the fact rather than seeking board approval. The animal control officer testified about the inconsistencies in the bite report and the pressure applied by Corinne to keep Jasper quarantined. The local news crew had grown to 3 different stations. A disability rights advocate had organized a small gathering outside the courthouse with service dogs and supportive signs. During closing arguments, Corinne's attorney attempted damage control, suggesting a settlement that would involve an HOA apology and policy changes. I declined. Your Honor, I said in my final statement, this case is about accountability. Mrs. Wilkins knowingly violated federal law, fabricated evidence, entered our property illegally, and took a service animal from a disabled child. She did this not out of ignorance, but out of a deliberate desire to exert control, even at the expense of my son's well-being and independence. This behavior cannot be settled away with an apology and a promise to do better. Judge Mercer took only 1 hour to return with his decision. The courtroom was packed as he delivered his ruling. Having reviewed the evidence presented, this court finds in favor of the plaintiff on all counts. The actions of the Oakwood Heights HOA, and specifically those of Mrs. Corinne Wilkins, represent a clear and disturbing violation of the Americans with Disabilities Act and numerous state laws protecting disabled individuals from discrimination. He continued, his voice carrying the weight of moral as well as legal authority. This was not a case of misunderstanding or overzealous rule enforcement. The evidence clearly demonstrates a pattern of targeted harassment, culminating in the unconscionable seizure of a service animal from a hearing-impaired child. The judgment included substantial damages to be paid by both the HOA and Corinne personally. A permanent injunction preventing any HOA interference with Jasper, mandatory disability compliance, training for all HOA board members, and the establishment of an oversight committee to review HOA enforcement actions. Most significantly, Judge Mercer issued a separate restraining order preventing Karen from coming within 100 yards of Noah, Jasper, or our home. This court cannot allow those who wield authority, however limited, to use it as a weapon against the vulnerable members of our community, he concluded. Such behavior corrodes the very fabric of civil society. As the courtroom began to empty, I noticed several board members huddled in intense conversation, pointedly excluding Karen. Neighbors who had previously been too intimidated to speak approached us with quiet congratulations and apologies for not standing with us sooner. A reporter caught up with us outside the courthouse. "Mrs. Matthews, how do you feel about the verdict?" "Relief," I said simply. "Relief that my son can feel safe in his own home again. Relief that justice was served, and hope that this case might help other families facing similar discrimination." "And what would you say to other homeowners' associations about service animals?" the reporter pressed. "I would remind them that federal law is not optional. Service animals are not pets. They are medical necessities that provide independence and safety to people with disabilities. No community rule or personal preference can override that fundamental right." As we drove home, Noah signed from the backseat, his hands moving quickly with excitement. "Is it really over? Jasper can stay forever now." "Yes," I signed back, meeting his eyes in the rearview mirror. "Jasper is home for good." But as we turned onto our street, I wondered what awaited us. Had we won the legal battle only to face a different kind of community backlash? The first sign that something had changed appeared the morning after the verdict. A vase of fresh flowers sat on our front porch with a card signed by several neighbors. "Welcome to the real Oakwood Heights," it read. "We are so sorry." Over the next few days, more gestures followed. Mrs. Garcia from next door brought homemade cookies. The retired couple across the street offered to watch Jasper if we ever needed help. The family down the block with 2 young children asked if their kids could meet a real service dog, as they had been learning about working animals in school. A week after the trial, an emergency HOA meeting was called. I attended with a degree of trepidation, unsure what to expect. The community center was fuller than I had ever seen it, with residents standing along the walls when the seats filled. Bill Jensen, who had voted to dismiss the complaints against us, stood at the podium. "As you all know, recent events have forced us to confront some uncomfortable truths about how our community has been governed," he began. "The court ruling against our HOA was not just a legal defeat, but a moral one." He announced Karen's resignation from the board, effective immediately. The announcement was met with scattered applause. "More importantly," he continued, "we are implementing a complete overhaul of HOA policies, starting with a new commitment to inclusivity and legal compliance. We have established a resident advocacy committee to review all complaints and enforcement actions before they are implemented." To my surprise, he asked if I would be willing to serve as a legal consultant for this committee. "We need your expertise to ensure we never find ourselves in this position again." I agreed, seeing an opportunity to create lasting change. As the meeting proceeded, I was struck by how many residents approached the microphone to share their own stories of intimidation under Karen's leadership. The Iranian family, who had been repeatedly cited for traditional decorations during their New Year celebration. The elderly widower who had been fined when his lawn care service was delayed during his hospitalization. The young couple whose accessibility ramp had been deemed architecturally inconsistent. After the meeting, a local disability rights organization contacted me. They had been following the case and asked if I would consider heading a new initiative focused on housing discrimination against service animal handlers. The publicity from our case had exposed a pattern of similar HOA overreach throughout the state. Within a month, I had established a nonprofit called Service Access Matters, SAM, offering free legal advice to service animal handlers facing housing discrimination. We named Jasper our honorary mascot. The logo, a golden retriever with alert ears, became recognized by HOAs throughout the region, often prompting them to reconsider discriminatory policies before litigation became necessary. But the most profound change happened at home. Noah began to thrive in a way I had not seen before. Without the constant stress of Karen's surveillance and harassment, he relaxed into his new school and community. Jasper continued his perfect service, alerting Noah to sounds, alarms, and approaches, allowing my son the independence that every 12-year-old craves. 6 months after the trial, we hosted a neighborhood barbecue in our backyard. Looking around at the diverse group of neighbors chatting, laughing, and sharing stories, I marveled at the transformation. Children played on our lawn, some of them practicing the basic sign language Noah had taught them. Jasper moved among the guests, his service vest off for the day, but his training still evident in his gentle demeanor. Bill Jensen, now the interim HOA president, raised his glass in a toast. To neighbors who became friends, to differences that make us stronger, and to the courage to stand up for what is right. Later that evening, as Noah and Jasper headed upstairs for bed, Noah paused and signed to me, "I love our home now." Those 5 words made every moment of the battle worthwhile. The law is not just about punishment. It is about protection. It is about creating spaces where everyone belongs, where differences are accommodated not as special favors but as fundamental rights. Sometimes, it takes a fight to remind us all of that truth. As for Karen, I heard she moved to a non-HOA neighborhood across town. Sometimes the best justice is simply creating a world where people like her have less power to hurt others. And Jasper, he continues his important work, completely unaware that he became the symbol of a much larger fight. To him, each day is simply about being there for Noah, alerting, guiding, comforting. In the end, that perfect loyalty was what we fought for and what we won.